الله أكبر الله أكبر. أشهد أن لا إله إلا الله. أشهد أن محمدًا رسول الله. حي على الصلاة حي على الفلاح. قد قامت الصلاة قد قامت الصلاة. الله أكبر الله أكبر. لا إله إلا الله.
استقيموا واستووا واعتدلوا يرحمنا وإياكم الله. اخشعوا في صلاتكم، صلوا صلاة ودع. استووا. الله أكبر. الحمد لله رب العالمين الرحمن الرحيم مالك يوم الدين. إياك نعبد وإياك نستعين. اهدنا الصراط المستقيم، صراط الذين أنعمت عليهم غير المغضوب عليهم ولا الضالين. يا أيها الناس اعبدوا ربكم الذي خلقكم والذين من قبلكم لعلكم تتقون. الذي جعل لكم الأرض فراشا والسماء بناء وأنزل من السماء ماء فأخرج به من الثمرات رزقا لكم فلا تجعلوا لله أندادا وأنتم تعلمون. وإن كنتم في ريب مما نزلنا على عبدنا فأتوا بسورة من مثله وادعوا شهداءكم من دون الله إن كنتم صادقين. فإن لم تفعلوا ولن تفعلوا فاتقوا النار التي وقودها الناس والحجارة أعدت للكافرين. وبشر الذين آمنوا وعملوا الصالحات أن لهم جنات تجري من تحتها الأنهار كلما رزقوا منها من ثمرة رزقا قالوا هذا الذي رزقنا من قبل وأتوا به متشابها ولهم فيها أزواج مطهرة وهم فيها خالدون. إن الله لا يستحيي أن يضرب مثلا ما بعوضة فما فوقها فأما الذين آمنوا فيعلمون أنه الحق من ربهم وأما الذين كفروا فيقولون ماذا أراد الله بهذا مثلا يضل به كثيرا ويهدي به كثيرا وما يضل به إلا الفاسقين. الذين ينقضون عهد الله من بعد ميثاقه ويقطعون ما أمر الله به أن يوصل ويفسدون في الأرض أولئك هم الخاسرون. كيف تكفرون بالله وكنتم أمواتا فأحياكم ثم يميتكم ثم يحييكم ثم إليه ترجعون. هو الذي خلق لكم ما في الأرض جميعا ثم استوى إلى السماء فسواهن 7 سماوات وهو بكل شيء عليم. الله أكبر. سمع الله لمن حمده. الله أكبر. الله أكبر. الله أكبر. الله أكبر. الحمد لله رب العالمين الرحمن الرحيم مالك يوم الدين إياك نعبد وإياك نستعين اهدنا الصراط المستقيم صراط الذين أنعمت عليهم غير المغضوب عليهم ولا الضالين آمين. وإذ قال ربك للملائكة إني جاعل في الأرض خليفة قالوا أتجعل فيها من يفسد فيها ويسفك الدماء ونحن نسبح بحمدك ونقدس لك قال إني أعلم ما لا تعلمون. وعلم آدم الأسماء كلها ثم عرضهم على الملائكة فقال أنبئوني بأسماء هؤلاء إن كنتم صادقين. قالوا سبحانك لا علم لنا إلا ما علمتنا إنك أنت العليم الحكيم. قال يا آدم أنبئهم بأسمائهم فلما أنبأهم بأسمائهم قال ألم أقل لكم إني أعلم غيب السماوات والأرض وأعلم ما تبدون وما كنتم تكتمون. الله أكبر. سمع الله لمن حمده. الله أكبر. الله أكبر. الله أكبر. الله أكبر. الله أكبر. الله أكبر. سمع الله لمن حمده. الله أكبر. الله أكبر. الله أكبر. الله أكبر. الله أكبر. سمع الله لمن حمده. الله أكبر. الله أكبر. الله أكبر. الله أكبر. السلام عليكم ورحمة الله. السلام عليكم ورحمة الله. استغفر الله. استغفر الله. بسم الله الرحمن الرحيم. الحمد لله. الصلاة والسلام على رسول الله وعلى آله وصحبه ومن والاه. أما بعد. So today, subhanAllah, the topic that I was preparing for you for our series, the End of Times events, it was about أول منازل الآخرة, which is al-qabr, which is death, basically. And subhanAllah, we have today something very relevant. As you can see here in the projector, the screen, you can see the Islamic State planning, the will versus trust. And me personally, I get a lot of questions about that trust and will and what is the proper way of doing it, when should I do it, right? So alhamdulillah Rabbil Alameen, we brought to you an expert who can actually answer these questions from legal perspective. We have brother, mashallah, brother Fawaz Maruf, he's an attorney at law, mashallah, that's his area of expertise. He's been doing that for years. Alhamdulillah, he presented already before. It was actually between Maghrib and Isha, but we noticed that there are a lot of questions. So I mashallah, humbly requested him to join, and he kindly, mashallah, accepted to spend few minutes with you, inshallah, Rabbil Alameen, to answer some questions about the trust and will. I think this is very important. The Nabi Sallallahu Alaihi Wasallam, he encouraged us. He says, don't sleep until you have your trust and your will under your pillow, basically, right? Because we don't know what's going to happen tomorrow. So we have an expert here. So please make the most, inshallah, of this session. Alhamdulillah here. Brother.
Assalamu alaikum. My name is Fawaz Maruf. Thanks to the masjid for letting me do the workshop earlier after Maghrib. I knew there was a lot of questions. I figured there would be something in the community a lot of people have questions about, and a lot of people just needed basic knowledge of. So I'll be happy to answer any of your questions for you. Okay, I'll just go quickly, just about 10 minutes, just giving the basics of estate planning, Islamic estate planning, what's required by Texas law, and how to incorporate it in there. I want to talk about first about Texas law, why you need an estate plan in general. Number one thing, if you don't have an estate plan in Texas, you don't dictate who gets your assets, what happens to them. The state of Texas already has a formula, so they dictate what happens to it. If you want a timely distribution, you need to have your estate plan ready, or the probate court that will take longer. Almost 100% of the time I've seen it always take a lot longer without a will or without any estate plan, and far less attorney fees if you do go to probate court with a will. Here's the different probate types, this dependent and independent. So just in a nutshell, for an estate plan, you do need either a will, a last will and testament, or a revocable living trust. You also need a declaration of guardianship for your children to say who gets the authority over them, the parental authority and financial. You need a power of attorney, medical power of attorney, and HIPAA release. In general, the last will and testament is the basic one you get to dictate what happens to your assets, but there is a court process with that after death for husband and one for wife. The revocable living trust avoids that probate process after death. So that's a benefit of the trust. Why Islamic estate planning? Quickly, just in the Quran and Hadith, there's a religious duty if you have anything at the time of your death to distribute it in a specific manner. And to do it according to Texas law, the only way to do it is with a will or with a trust. Otherwise, if the state dictates, their formula is contradictory to how Islamic inheritance works. So automatically it's contradictory. So the will, the basics of it is you get to dictate, here's my funeral and burial rights. I want Islamic funeral or burial. You pay your debts, taxes, and expenses. Then you have up to 1/3 to give to whoever you want as a charity based on an authentic hadith. So you can give that to adopted child. You can give that to anyone that wouldn't normally inherit based on Islamic law. And then the rest will go according to Islamic law. The will is very easy. That's the pro of it. You just sign it. You don't need to disclose your assets. And at the time of death, you go to the court process, and it gets handled. The cost of it is basically the probate court. Your family will have to go to court and hire an attorney after death to sell your house, to access your accounts, and do all of that. That's where the revocable living trust comes in. It's a substitute for the will. It does everything the will does, but it's intended to avoid probate process. Why? You put all your assets in the trust where, let's say you and your wife are the managers of the trust, but since you pass away, there's nothing in your name, it's all in the trust, you don't go to court. But the trust says we have to distribute your assets Islamically, and the trustee or the manager of the trust at that time does it for you. So you automatically avoid probate for husband and for wife because it's all included in there. The cost of it is it's more upfront cost and more legwork at the beginning, and you have to change the title of your assets. So your house, you transfer it to the trust. Your bank accounts, you incorporate the trust or add it as a beneficiary upon death. So each of your assets you have to look at and incorporate in the trust. One-time thing. In the future, anything you buy or sell, directly in the trust and directly out of the trust. So you do the legwork now so your family won't have to do it in the future as a theory. No court process, no attorneys later on. Just basic summary, the will, you go through an easier probate process, maybe a few weeks, maybe a little over a month before you can access the assets. Otherwise, it could take a lot longer. It's higher fees. So the will is what everyone should at least have. If you want to go one step up, the trust, you do a little more legwork up front, but you avoid the probate court process for your family in the future. If you and your wife are trustees of the trust, one passes away or both, the next day, the assets can be distributed to your beneficiary. You don't have to wait for court. It's not public record. And that's why it's becoming more and more popular and a better tool just for everyone, whether it's Islamic planning or regular estate planning. A lot of people are going to the revocable trust. Your house and your assets, you don't need to lose any homestead exemptions, any benefits you have as an individual you keep, and how do you tax the trust? It's the same as individual. You use your social security number. It's not a separate entity. So I see accountant here. He's a great guy to ask about those questions, but revocable trust, it's a grantor trust. It's under your social security number generally. It's not a separate entity. So that's the main benefit of the trust, not liability protection, but avoiding probate and as a substitute for a will. And I don't want to take up too much of your time, but if you have any general questions, I'll be happy to answer them for you. So a brother asked if you don't have a will or a trust, but you have beneficiaries, like payable on death, the beneficiaries bypass the will and trust. So if all of your assets have a beneficiary, then you don't need the will and trust because there's nothing else. If you want it Islamically, the best way is to do the trust because it distributes it Islamically. So you name your trust as beneficiary, or you name the trust as the owner of your house. You do that with all your assets, so everything that passes through it is distributed Islamically, and that's the best you can do at that point, just to make sure all your assets are distributed accordingly. So there's no tax advantage between both. If you do a revocable trust, you don't get any special tax advantages, but you don't lose anything because it's just as if you owned it individually. The purpose is to make it kind of a hybrid between an entity and you individually. So you don't need to change anything as far as taxes, homestead, everything stays the same. If you want to add protections, let's say you have a rental property or a business, you create LLCs for each asset and then you incorporate it in the trust. So if you get sued for one rental property, they can only go against that property, none of your other assets. That's the best way to add liability protection to it. Any other questions? That's a good question. Brother asked, what if you have a will but you lose the original copy? In Texas, the original copy, the one you actually sign and notarize and witness, is the only one the courts accept. If you lose it, you're considered as dying without a will, and you go through the dependent probate proceeding, which is the longer one, the more costly one. So the best way is, safeguard it in your house, not a safety deposit box because people need to access it. Or a lot of the probate courts here, I know Collin County, Tarrant County, Denton, you take it to them, you pay a one-time fee, they'll hold it for you for life. If you pass away, whoever your executor is goes there and picks it up, and that's a good way to place it. Same goes for the trust. Yes, they'll hold the trust as well. Yeah. And the banks, when you incorporate your bank accounts, you want to add all your assets in there. They're going to ask for a copy of the trust. Generally, the whole point is to avoid court for the trust. So the will is the main one where you need the original copy. The trust, I can see where the copies of it would work. Yes. Yeah, the dependent and independent. Yeah, so the dependent administration, the one on top is dying without a will. The attorney fees, I haven't seen less than, even if it's flat fee, less than $5,000 for the attorney fees, plus court fees. The independent, I've seen them as low as about $2,500 plus court fees, but it's just a process. And then you have to get an attorney and you have to wait that time. And that's for each estate, like that's for husband and wife if each owns separate property. There's different probate proceedings, simpler ones, but this is kind of the default, the general ones. At the end of the day, you just want to avoid any court process if you can. Any other questions at all? I mean, personally, yes, because you avoid the probate, but at the same time, it depends on everyone's situation. It is more cost upfront, and you have to transfer all your assets in the trust. Some people just don't feel comfortable doing that or don't want to do all of that, because if something's not in there, then it's out of the trust. Each trust has a will also, in case you forget an asset, it'll put it right back in there, but you have to go to probate. But overall, if you want to put the legwork up there, trust is, of course, more convenient in the future. Every attorney is different. I can tell you, it ranges a lot. Like for me, I do the wills for around $600 for husband and wife total, and then a trust is about $1,000 more or so, depending on the situation. But generally just a flat fee for everything. There's attorneys that do hourly, and there's just different fee structures, so whatever you're comfortable with. There's other attorneys that do those type of structures. Any other questions? Mhm. It- Yeah, that's a good point, because people say, like, when they do a trust, they're like, well, the beneficiaries, I'll just name my wife. I'm like, well, yeah, but you lose the benefit of making it Islamic. So you're right, with the will, it's not going to be perfect unless, I don't think they can separate the beneficiaries in specific portions, right? Yeah. And then whoever, yeah, based on their formula. Yeah, that's a good point. Um, mhm. No, that's a good question. So this is only if you have a trust, you change the title, not a will, of course. So the trust, you change the title. The house is doing a deed. That's how you do that. The bank accounts, you incorporate the trust. So you make the trust as a co-owner or beneficiary upon death, or open a separate trust account and make that your only one. You have three options. 401k, all of those, life insurance, you can make the trust beneficiary. With cars, personal property, jewelry, there's no way to transfer property like that. There's no method, but it's included in the trust. So if you do have a lot of jewelry, the trust says the jewelry goes according to Islamic law. It would just be a court process if someone distributes the jewelry differently, and they say, hey, this is actually not distributed according to here. There's no way to actually transfer the property. You just write it in the trust, and that's all you can do. So the trustee for this trust, you would want you, and if you're married, your wife as the trustees. Upon death of both of you, you can do a lawyer or another company or a family member, whoever you want. Initially, you want to just have both of you on there, you alone or both of you as trustees. Until the death of both of you, then another one can come in once the trust terminates. Yes, yeah, and my cards are over there, and feel free, if you have just general questions or consultation or anything, feel free to call or message me, and we'll set something up for you. Okay, thank you so much. Yeah. And I'll be over there if you have more questions. Thank you. Sorry.
No, you're good. No, you're good. Mashallah. It's very important.